Section 14 of the Companies Act 2013 deals with the alteration of articles. Definition: Section 14 deals with the alteration of articles of association of a company. It empowers a company to modify, add, delete, and replace provisions in its articles by passing a special resolution, subject to the Companies Act and the conditions contained in the Memorandum of Associations. Meaning of alteration of article of association. Uh, Alteration may include addition of new articles, deletion of existing articles, modifications of existing provisions, conversion of a private company into a public company, conversion of a public company into a private company. All provisions of Section 14 are: Section 14, subsection 1, power to alter articles. A company may alter its articles of association by passing a special resolution subject to the provisions of the Companies Act 2013, conditions contained in the memorandum, if any. Important point is a special resolution is required for alter of article of associations. Conversions under sections 14 subsection 1. Private company to public company. A private company may alter its articles and convert it into a public company through a special resolutions. Public company into private company. Public company may convert into a private company by altering its articles. Approval of the central government is required for such conversions. Earlier approval of NCLT tribunal was required. The Company Amendment Act 2019 shifted its approval to the central government. For proviso to Section 14 subsection 1 is: if a private company removes its restrictions that are mandatory for a private company under the act, it automatically ceases to be a private company from the date of such alterations. For example, if a XYZ Private Limited removes restrictions on transfer of shares, number of members, and invitations to public, it will automatically become a public company. Clear? Section 14, subsection 2, filing with the ROC. After alterations, a company of the altered articles must be filed with the ROC. If the central government approvals is required, a copy of the approval order must be also be filed. Filing must be done within 15 days. ROC registers are alterations. Section 14, subsection 3, effects of registrations. Once the alteration is required by the ROC, the altered articles become a legally valid. They are treated as if they were originally contained in the Articles of Associations. Features of the Sections 14. Flexibility in management allows companies to update internal rules according to the change of business need. Shareholders control. Special resolutions ensure that the major changes are approved by the members. Conversions facility provides a legal mechanism for conversion between the private and public. Regulatory overrides. Certain conversions require government approval to protect stakeholders. Legal validity. Registered alterations become fully enforceable. Advantage of Section 14 is easy modifications of internal rules. The company can revise its governance structure when required. Supports business growth, facilitates expansions, restructuring, and modernizations, enable conversions, allow movement from private to public status and vice versa. Better corporate governance rules can be updated to match certain legal and business requirements. Protect shareholders. Special resolutions prevents arbitrary changes by management. Disadvantage of the sections 14. Compliance burden requires resolutions, filing, and procedural compliances. Additional cost, ROC, files fees, and professional charges may arise. Time consuming and process. Certain alterations requires approvals and documentations. Government approvals requirement. Public to private conversions cannot be done freely. Risk of members' dispute. Major alterations may lead to disagreement among the stakeholders. The key aways from this section is Section 14 gives companies the power to modify their internal rules, ensuring flexibility, growth, and compliance with the laws.